My young friends, today we shall discuss about the concept of right. As an introduction, by concept of right we mean an idea or principle relating to the term right. Rights are conferred by bodies of the rules for human conduct and conferred upon the human beings for observance by human beings. In the primitive societies, before they are politically organized, man was ruled solely by one set of the rule, that is customary rules. At a time, law and morality are both rules of human conduct. After the age of the pure customary law, the period begins of codification and man-made law, which is then followed by statutory laws made by the elected lawmakers and the rules framed by the executive bodies pursuant to statutory laws. Law thus enacted consists in the conferment of various rights and obligations for the observance of the human beings. Therefore, everyone is expected to be conversant with the concept of right. In defining the term right, different authors have defined right in different ways. For instance, Salman has defined right as an interest which is recognized and protected by a rule of right. It is any interest, respect for which is a duty and disregard of which is a wrong. A wrong presupposes an existence of right upon someone. Therefore, a wrongful act means which is contrary to the law, that is, which violates some legal right, which is vested in another person. In this sense, in order to hold an act to be wrongful, such an act must be known in law as a legal wrong, and only then one will have a remedy to maintain the right. Wrong here means only a legal wrong rather than a mere moral wrong. If somebody fails to help a starving man or save a drowning child, it is only moral wrong and no legal liability can arise unless it can be proved that there was also a legal duty to help the starving man and save the drowning child. Therefore, a wrongful act means an act which is contrary to law, and the same is actionable unless there is violation of a legal right. There can be no action under the law. If there is violation of a legal right, the same is actionable. Whether as a consequence thereof a person has suffered any loss or not. This is expressed by the maxim injuria sine damno, that is, infringement of a right conferred by law on someone which is or may be trivial. In view of the component of actionability, violation of legal right would mean what is actionable. An action can lie in a court of law even though such person has not suffered actual harm. When there is no violation of a legal right, no action can lie even though the act of someone has caused actual injury to another. This is expressed by the maxim damnum sine injuria. An injury without violence of a legal right and not actionable in the court of law. Now, let us make a mention about the characteristic of legal right. For an interest to become the subject of legal right, it must obtain not merely legal protection, but also legal recognition. The interests of the beasts are protected by the law under the Wildlife Protection Act 1972. Likewise, the Prevention of Cruelty to Animals Act 1960 made the act of cruelty to animals to be punishable. But beasts do not possess legal rights. He who treats a pupil in the school violates a duty imposed upon him by the law known as Right of the Children to Free and Compulsory Education Act 2009. He has violated a right vested in the pupils by the act, but he who ill treats a dog breaks no vinculum juris between him and the dog, for there is no legal obligation between them. According to Salmon, every right has the following characteristics. First, it is vested in a person who may be distinguished as the owner of the right, that is the subject of it. Secondly, it is avail against a person upon whom lies the correlative duty. He may be distinguished as the person bound. Thirdly, it obligates the person bound to an act or omission in favor of the person entitled. Fourthly, the act or omission relates to something which may be termed as object. And fifthly, every right has a title, that is, certain facts or events by reason of which the right become vested to its owner. The possible objects of right are many and various. A person may have a right over the material things, or he may have his rights in respect of his own person, that is, the right not to be physically injured or assaulted. In other words, right to safety. He has a right of reputation, that is, a right not to be defamed. He has right in respect of domestic relations, like the right to restitution of conjugal rights as against the wife who has withdrawn from his society. One may have right over intangible things, for example, patent rights, copyrights, trademark, and commercial goodwill. There may be rights which are created by contracts between a consumer and a service provider, a physician and a patient, master and servant, etc. Rights in the wider use of the term do not necessarily correspond with duties. In this generic sense, a legal right may be defined as any advantage or benefit conferred upon a person by a rule of law that could be illustrated in the four distinct senses. They are: first, duties prescribing as to how people ought or ought not to behave with regards to others who are said to have correlative claim of right. Secondly, liberties or freedoms to act or not to act. Thirdly, powers to alter existing legal situations. And fourthly, immunities from having legal situation altered. These four aspects of right, that is claim, liberty, power and immunity, concern legal relationship between person and are termed jural relations. They are all the species of rights. The distinctions of these terms are arrived at gradually. The jural relationship may be explained as hereunder: claim, duty, relation. A claim is simply a sign that some person ought to behave in a certain way. Every claim implies the existence of a correlative duty, since it has no content apart from the duty. Whether every duty implies a correlative claim, it may not always be. Duties in criminal law are imposed with reference to and for the benefit of the members of the society, none of whom has a correlative claim to these duties. Liberty, no claim relation. Salman has stated that just as my legal right in the strict sense are the benefits derived from the legal duties imposed upon other persons, so my legal liberties are of benefits which I derive from absence of legal duties imposed upon myself. The term right is often used in a wide sense to include such liberty, that is what I may do for myself. The interest of unrestricted activity which is allowed by law constitute a class of the legal right, clearly distinguishable from other class. A legal liberty is a legal right not to be interfered with by other persons in exercise of his activities. Power, liability relation. Power is what a person can do in relation to others and express as I can. Examples are right to make a will, to alienate property and various other powers vested in a judge and other officials for the due fulfillment of their functions. The correlative of the power is liability. It is the position of the person whose legal right may be altered by exercise of a power, that is, liability of a convict to undergo imprisonment when a sentence is passed by the judge against him. Immunity, disability relation. A power is the ability to change the legal relation of another, and an immunity is an exemption from having a legal relation changed by another. Immunity is thus exemption from the power of another. Immunity in short is no liability. The correlative of immunity is disability or no power. Disability is simply the absence of power. We may also discuss about the different kinds of legal rights. Salman has pointed out different kinds of legal rights, such as perfect and imperfect rights. A perfect right is one which corresponds to a perfect duty. A perfect duty is the one which is not merely recognized by law, but can be enforced. As regards imperfect rights, a glaring example is claims barred by the law of limitation. Positive and negative right. A positive right corresponds to a positive duty, and a negative right corresponds to a negative duty. Next is right in rem and right in personam. A right in rem corresponds to a duty imposed upon persons generally, and a right in personam corresponds to a duty imposed upon determinate individuals. Proprietary and personal rights. Proprietary rights are the rights of a person like owning lands, chattels, and share in a company, like which could be counted for value. A man's personal rights are those rights which pertain to status, like the status of a wife or a husband, or a father or a mother. Rights in re propria and rights in re elina. The rights in re elina can be termed as encumbrances, which limits or derogates from some more general right belonging to some other person in respect of the same subject matter. All others are right in re propria. Principal and accessory right. Every existence of right is capable of being affected by the existence of other rights. The right of an owner over his land is principal right, but the right of the long possessor over his land may be ripened into ownership by long possession. This is an example of accessory right. Then, primary and sanctioning right. The right of a person not to be defamed or assaulted is primary, but the right of that person to obtain pecuniary compensation from one who has defamed him is sanctioning right. There is legal and equitable right also. In England, legal rights are those which are recognized and administered by the common law courts. Equitable rights are recognized solely by the Court of Chancery. Vested and contingent right. A right is vested when all facts have occurred, which must by law occur in order for the person in question to have the right. A right is contingent when the same will vest with a person on the happening or non-happening of an event. Now friends, we can conclude. The conception of right is a fundamental significance in the modern legal theory because we cannot live without right, and which are recognized and enforced at law. Since the 17th century, people started thinking that man has certain inviolable and a basic right, that states are under a duty to protect and provide them. All the civilized nations of the world have certain fundamental rights of their own. These are the instances of conferment of legal rights. As for the Indian Union also, numerous rights are guaranteed, out of which some are for the citizens only and some are for all the persons. The rights like right to equality, freedoms, right against exploitations, freedom of religion, cultural and educational rights, and the right to constitutional remedies. These are mostly guaranteed against the state action and are enforceable by legal action. Therefore, they are all legal rights. In the course of analysis of the concept of rights, it may also be appreciated that all guaranteed rights and freedoms are to be exercised subject to such limitations and obligations which are to be determined by enacted laws of the states concerned. So, this much for today. Thank you very much.